Hi, my name is Behrouz Amouzgar. In this video, we're going to be talking about shareholder agreements and in particular, two types of provisions that are included in shareholder agreements. In this video, we will cover the first type, which is general rules about decision making. And in the next video, we'll talk about the limitations on the transfer of shares. So as you probably watched in another video that we had, there are different levels of decision making in a corporation, decisions by the shareholders, by the directors, by the officers. One thing that you need to keep in mind is that if all of the shareholders, directors, or officers sign a resolution, you do not require a meeting, an official meeting for making your decisions. However, even if one of them refuses to sign the resolution, then you're required to call an official meeting. And in a meeting, for the meeting to be considered official, you need to reach quorum, meaning that a certain number of shareholders or directors need to be present for that meeting to be considered an official meeting of the shareholders or directors. By default, a meeting of shareholders requires the holders of the majority of the voting shares. If you want, however, you can change that and you can increase the bar a little bit to have a higher threshold for the meeting to be considered official. For example, if we have two parties and one holds 51% of the voting shares and the other holds 49%, perhaps you would want to have a higher threshold for your quorum, because otherwise the party with 51% of the shares, if he or she is present, then the meeting can be considered an official meeting of the shareholders. Of course, the required notice will need to be provided to the other shareholder. If a meeting does not reach quorum, then you typically have a reconvened meeting. This is true for both the directors meeting and the shareholders meeting. And at the reconvened meeting, you can decide to either have the same quorum requirements as the initial meeting that did not take place, or you can have a lower quorum for that meeting in order to provide some incentive to those who were absent to be present, to make sure that they have their say in making the decisions. Once the meeting is official and reaches quorum, then you need to decide how decisions are made. Typically, for a meeting of shareholders, the majority, holders of the majority of the voting shares make decisions. If you want, you can increase that to have a higher threshold of approval for decisions that are made in the meeting of shareholders. For directors meetings, the quorum by default is the majority of the directors or the minimum number of directors set out in the Articles of Incorporation. And in Ontario, that can't be lower than 2/5. If you want, you can change this in the shareholders agreement, and the same goes with the quorum requirement for the reconvened meetings. And you can increase the quorum for both the initial meeting and the reconvened meeting. With respect to decisions, again, you decide whether the majority of the directors present at the meeting make decisions or a higher threshold, 2/3 or perhaps even all of them. One thing that's really important to keep in mind is that for certain decisions that are of importance to you, you can negotiate and make sure that you have your say, even if you're a minority shareholder. So, for example, you can require that for certain categories of decisions, a higher threshold of approval be required, such as 80% of the shareholders or even all of the shareholders. Some of the types of decisions that can fall in this category include the following. For example, amendment of the articles or the bylaws of the corporation, sale of all or substantially all of the assets of the corporation, a change in the nature of the business of the corporation, borrowing a large sum of money on behalf of the corporation, incurring a large expenditure on behalf of the corporation, even issuing dividends, or say entering into a lease or terminating a lease, or entering into an employment agreement, or terminating an employee. But in summary, you need to keep in mind that just because you're the minority shareholder doesn't mean that you don't have your say in the corporation. Keep in mind, try to find out what decisions are important to you. Try to enter into a shareholder agreement with your partner and negotiate for your presence in those types of decisions. Talk to your lawyer about it and ask for more information about this. I hope you've enjoyed this video. In the next video, we're going to talk about the limitations on transfers of shares. Thank you.